And we'll go right ahead with that first case, Progress Michigan versus the Attorney General.
May it please the court, Mark Brewer for the plaintiff appellant, Progress Michigan. I would like to reserve 10 minutes of my 30 minutes for rebuttal, if I may. Thank you. The late Judge Damon Keith once wrote that democracy dies in the dark. He was right. Transparency is the lifeblood of democracy, and the Freedom of Information Act in Michigan was intended to shed light on the business of government, as this court has recognized, for example, in the Swickard case, which this court said that the fundamental rule in Michigan is that citizens have the general right of access to and public inspection of public records. Going back to the Nowak case of 1928, this court described that case as placing Michigan in the vanguard of those states holding that a citizen's accessibility to public records must be given the broadest possible effect. In defiance of the tradition and the laws of this state, the Attorney General not only denied my client's FOIA request, but they insisted that the requested emails do not even exist. As the record indicates, this is untrue because Progress Michigan has lawfully obtained from other sources copies of some of the emails the Attorney General should have produced in response to its FOIA request. Defying the people's right to know, the Attorney General has fought for over 3 years to keep emails used to conduct government business secret, erecting every procedural obstacle imaginable in a desperate attempt to keep these emails hidden. What is in these emails that have led to such extraordinary efforts to hide them from the public or to even have destroyed them? The public deserves to know, and under the Freedom of Information Act, they have a right to know. In our briefs, we addressed all 5 issues that the court asked us to address. I'd like to briefly touch on 3 of them this morning and leave the balance of that to our briefs, unless the court has questions, of course, and focus more specifically and more length on 2 issues. Let me address 3 issues relatively briefly, again, subject to the court's questions. The first question the court posed was whether there was a sovereign or government immunity defense to a failure to disclose under FOIA. By this point in litigation, the Attorney General has abandoned the government immunity defense, which did not apply in any event, but the Attorney General has finally recognized that and has abandoned any claim of government immunity here. Under this court's ruling in Mick versus Kent County, sovereign immunity, common law sovereign immunity no longer exists in this state. It's been abolished. And so there's no basis for a sovereign immunity defense either. The second issue the court asked us to address was whether the Freedom of Information Act waived either governmental or sovereign immunity if it exists. And I believe, even with the Court of Appeals' adverse decision to my client, that that court and the parties agree that FOIA, by allowing a dissatisfied requester to go to court, has waived immunity even if it exists. The third question the court posed was whether MCL 600.6431 applies to a FOIA appeal. By its very terms, it does not. That section addresses damages claims against the state in the nature of tortious injuries. This is not a tort case. This is not a damages case. This case is in the nature of equitable relief seeking to compel the release of public records. It's a successor to the mandamus actions which existed in Nowak, for example, prior to the enactment of the FOIA. This is not a damages case, and the Court of Claims Act does not apply at all by its own terms. Moreover, as this court has said, the purpose of the Court of Claims Act is to implement the Government Tort Liability Act. Again, there's no tort here. There's no damages here. This is a FOIA enforcement action.
Mr. Brewer, does MCL 66434 sub 2 apply to these cases?
Sub 2, Your Honor?
It's under the Court of Claims Act, and it reads, except as provided in this section, the pleading shall conform to the rules for pleading in the circuit court, and then subsection 2, the complaint shall be verified. The pleadings of the state need not be verified. Does this provision apply to the complaint that was filed in this case?
No, Your Honor, it does not. And it was our position from the very beginning that it does not.
Why?
Why? Because, again, the Court of Claims Act does not apply here. There's jurisdiction in the Court of Claims, But there's nothing in either the Foia or the Court of Claims Act which imposes the verification requirements or the notice requirements on a Foia claimant.
Okay.
Returning to where I was, regarding 6431, again, the Government Tort Liability Act does not apply here, and of course, by its own terms, it does not apply as well. I would like to spend the balance of my opening remarks focusing in much more detail on issues 4 and 5 for the court. Issue 4 was whether a lack of a verified complaint made it invalid from its inception and incapable of amendment. And issue 5, which the court asked us to address, was whether the verified amended complaint related back to the date of the original complaint for purposes of the statute of limitations under Foia. So that even if...
Counsel, can I ask
Yes, Your Honor.
what to me is kind of a threshold or preliminary question? Given that both parties attempted to settle this case several months ago, contingent upon this court vacating a Court of Appeals opinion, we didn't do that at that time, but nonetheless, in light of that history, why should this court even retain interest in resolving this case if it's apparently possible and conceivable that these documents can be turned over at any time?
Well, Your Honor, so far they've not been tendered by the defendant in this case. They continue to insist that they either don't have them or they were destroyed or they don't exist. There's been no tender of the documents to my client. So this is still a live controversy. And if you reverse the Court of Appeals as we ask and remand to the Court of Claims, I have pending discovery requests, interrogatories, to try to find out how our Foia request was treated by the Attorney General, what inquiries they made, what process they followed, and there may well follow depositions to try to get to the bottom of this. Do these exist? If they don't exist, were they destroyed and by whom? So there's very much a live controversy here, Your Honor, until the Attorney General tenders the emails we
But
requested.
you don't see that this court can view the current situation as one in which the Attorney General might well be inclined to turn over those documents once this case is resolved at the very least.
Your Honor, that's a hypothetical. The Attorney General's been able to do that for the last 3 years. And yet here we are, having fought hard through 3 courts now over the last 3 years, and still no emails have been tendered to my client.
Whatever has occurred within the past 3 years, what's happened within the past several months certainly communicates an inclination to turn over the documents at this juncture, doesn't it?
I don't believe so, Your Honor. Because an inclination is not actually turning them over. And so here we are. If the Attorney General had brought the emails here this morning, this case would be resolved, and we would move to dismiss as moot. But they continue to insist that they do not have to turn them over and or that they don't exist. And my client has a right to get to the bottom of that under the Freedom of Information Act. I hope they do turn them over, Your Honor, and we wouldn't darken your door with these kind of cases. But as long as they insist that they don't have to or that they've been destroyed, we have a live controversy.
Mr. Brewer, the Attorney General concedes in their brief that according to Pike versus Northern Michigan, 6431 doesn't apply to it. Because it's not the state, it's a subdivision of the state. And you did not address that case. Do you have a view on that?
I'm sorry, Your Honor, the case again?
Pike versus Northern Michigan University?
I did not address the case, and what is the question?
The Attorney General, in their brief, concede that based on that case, it's a Court of Appeals opinion, that 6431's notice requirement does not apply because they're not the state, they're a subdivision of the state. Do you have a view on that question?
That's not been the position, as I understand the Attorney General here. I mean, that's why
They believe Pike was wrongly decided, I'll say that. They don't believe Pike was correctly decided.
I agree. I think it was correctly decided, but obviously they have a different position that, as Justice Zara asked about a few moments ago, the Attorney General takes a position that the notice and verification requirements do apply.
Yeah.
And that we should have satisfied them.
Okay. I'll ask them.
Well, can I follow up on that? If that's the case, why would anyone ever sue the state in the current context as opposed to suing a particular individual, as in this case, the Attorney General? What would be the purpose of doing that?
Well, Your Honor, the request was made to the Attorney General, then Bill Schuette, in his official capacity. This was never a personal lawsuit. It was in his individual capacity as the head of a principal department, the Department of Attorney General.
So this should be viewed, this dispute should be viewed as tantamount to one in which the state's being sued.
Correct, yes. And that's why when we had a new Attorney General, the pleadings were changed. For example, it was no longer Progress Michigan versus Schuette, it was versus Attorney General.
So at no moment that a specific individual, in this case Bill Schuette, was sued as opposed to the state more generally.
Not sued individually, Your Honor, no. And the emails that we sought were emails that circulated, from what we can tell, within the executive department of the Department of Attorney General among a couple of dozen individuals, all of whom were named in our original FOIA request and in our complaint. Officials of the Department of Attorney
Freedom of Information
General.
Act would not apply to him in his individual capacity, would it?
I'm sorry, Your Honor?
The Freedom of Information Act would not apply to him or anyone else in their individual capacity, would it?
If they are performing government business with their private emails, yes, it would. In this case,
I mean, if I served a Freedom of Information Act on you, would you have to turn over all your emails?
no, Your Honor, I mean, I'm not subject to the Freedom of Information. I'm not a public body, but the Department of Attorney General is a public body, and these
You sued
employees
him in
work.
his official capacity for work done in his official capacity,
Correct,
right?
correct. I mean, every indication we have is that these emails were used to conduct government business. We were not asking Mr. Schuette or any of his employees for emails about their personal business. But they did, and we have proof of that by the emails that we submitted with our complaint, that they were using private email accounts, not state of Michigan email accounts, to conduct government business. That converted those emails into public records under the Freedom of Information Act, subject to FOIA.
Can I get back to just a technical point? Assume for the moment that we believe that Pike was correctly decided, and therefore 6431, the notice provision, does not apply. But assume further that Justice Zara's point is well taken, that 6434 did require your complaint to be verified. I've been scratching my head in this case for a while because it does not appear to me that your amended complaint is properly verified. It appears to be signed, it appears to be notarized, but I don't see anyone, a party or otherwise, who's verifying the facts that are alleged in the complaint, which is, of course, what a verified complaint must contain under our court rule. So am I wrong? Is your amended complaint properly verified, or is it not?
We believe it is, Your Honor, and the parties have certainly acted like it has been throughout the course of this litigation since then. Again, under the rules of amendment, if it's necessary to further amend the verified complaint upon remand, we will. Again, but this is just an example of what has happened here in terms of one procedural obstacle after another, preventing us from getting to the substance of the dispute here, which is very, very important.
All right, so why don't you move on to that and tell me what you think of Scarcella and whether that would allow us to recognize, I guess, that this case actually exists, and number two, whether any amendment would relate back to the original complaint.
Right. So the Court of Appeals, we think, made two fundamental errors, ignoring governing statutes, first being 600.1901, which governs when a civil action is commenced. It says a civil action is commenced by filing a complaint with the court. There are no preconditions to that statute. It doesn't say a verified complaint. It doesn't say a complaint complying with prerequisites set out in any statute. The legislature has said that a lawsuit is commenced by filing a complaint. And the Court of Appeals ignored that in proceeding to analogize this case to Scarcella. It went on to ignore the tolling statute that the legislature has passed, 5856A in this case, which says at the time the complaint is filed, the statute of limitations is tolled. It places no conditions on the tolling of the statute of limitations. It doesn't say the complaint has to be verified. It doesn't say the complaint has to comply with any prerequisites. It simply says the filing of the complaint tolls the statute. And all these issues of defects are to be fought out later. So the Court of Appeals ignored those two statutes, applied Scarcella to do what it did here, analogize the medical malpractice statute there to the statute here at issue. There are fundamental differences between the two statutes, which we describe in our brief, but I want to go to Scarcella, if I may, Your Honor, and be responsive to your question. Respectfully, this court's decision in Scarcella has proved unworkable and chaotic in practice. And what will happen here if the Court of Appeals is not reversed is that that chaos will now spread to litigation in the Court of Claims and under the Court of Claims Act. This court's had to grapple with the chaos that Scarcella has caused. In Sathian versus Simmons, 497 Michigan 8 in 2007, the defendant there argued that a default judgment entered against him had to be lifted because the original complaint was defective. So litigation occurred. The defendant ignored everything, ignored his obligations to answer and so forth, so far that a default judgment was entered. And he said, no, you can't enter a default judgment against me because the complaint was a nullity. This court saw the chaos that that would cause and said, no, we're not going to allow that to happen. The defendant must answer the complaint and then contest, in that case, the affidavit of merit. The court said this more orderly process of honoring the presumption of the validity of pleadings, requiring an answer and allowing the defendant to challenge the affidavit reduces the chaotic uncertainty that allowing a defendant to decline to answer would introduce. The same chaos this court had to deal with in Sathian will be introduced into the Court of Claims and the Court of Claims Act if the Court of Appeals is not reversed. For example, a defendant like the Attorney General could simply ignore a complaint after it's served on them because they believe there's some defect in the complaint that renders it a nullity. They don't have to answer. They don't have to respond to discovery requests. They don't have to litigate at all. A defendant could even allow the case to proceed. And at some point, months or years down the road, say, oh, guess what? This complaint was a nullity from the beginning, and so all the proceedings to date have been for naught. They've been futile. It would even allow sandbagging. Imagine the situation where a plaintiff files what the defendant believes is a defective complaint, and then the defendant plays along until the statute of limitations expires, and then says, oh, this complaint is a nullity. And the statute has expired and the plaintiff has no remedy. The games playing and the chaos with the court rules and the court procedures will be endless if defendants are allowed to say, this was a nullity, it never should have been honored from the get-go.
You didn't make these arguments in your brief, though. You simply said in your brief, the statute in question here is different from the statute that was at question in Scarcella, so Scarcella has no application.
That's correct. Now, what I'm doing here, I'm being responsive to Justice Viviano. The court need not overrule Scarcella, even though I think it should, need not overrule Scarcella.
You said that in your brief.
No, Your Honor. Well, if I may,
Yeah.
the court need not overrule Scarcella, even though I think it should be, for the reasons that have been indicated and in other opinions and by justices of this court, but you need not do that for us to prevail in this case. You can simply reverse the Court of Appeals based on the statutory argument that I made, Your Honor. It's a narrow basis to reverse what the Court of Appeals did here to prevent the chaos of Scarcella from spreading now into the Court of Claims and under the Court of Claims Act. And you can leave Scarcella versus Pollock for another day, for another case, when you can decide whether or not you want to overrule it. But here we ask you, please prevent the chaos that Scarcella would introduce into the Court of Claims Act, FOIA litigation, and so forth, by reversing the Court of Appeals on that grounds, that narrow grounds, Your Honor, that would not require you to reach Scarcella here, even though I think at some point you should reach it.
That becomes more difficult if we conclude that MCL 600.3434-6434-2 is more on point than 6431-1.
Well, again, the basis for the defense here has been the lack of notice and verification under 6431. That has been the entire basis of the Attorney General's defense from the very beginning of this case. They've not cited any other basis. If you want to send us back to litigate that issue, that would be fine. But again, the basis here all along through 3 years of litigation has been 6431.
We'll look forward to the time, though, when you can demonstrate the chaos that Scarcella's introduced into the law as opposed to perhaps the clarity it's brought to the law in the area of medical malpractice. But
I understand, Your
that's
Honor.
for another time, I agree with you.
Yeah, you and I may have, obviously we have different perspective on that.
Your point is, I think, if I understand it, that it is, if we say in this case that a complaint that's not verified doesn't toll the statute of limitations, that will apply not just in the Court of Claims, but in every instance in which a complaint is required to be verified. And and it seems to me that same logic would apply to any other procedural requirement connected to the complaint. So for example, the court rules require that certain written instruments be attached to the complaint. In various types of cases, contract cases, for example, anytime a claim or defense is based on a written instrument. And so it seems to me the Scarcella rule would also say that all of those cases, if the complaint's not filed with the proper written instrument attached, those don't toll the statute of limitations either. And so there will be a proliferation of cases in which the statute of limitation was not conformed to by plaintiffs because of technical deficiencies with the pleading.
I think you're right, Your Honor. I think every capable, and there are many capable defense attorneys in this state, will make that argument. And so this will not be restricted to the Court of Claims Act or the Court of Claims. It will be expanded far beyond the medical malpractice context in which it originated. Briefly, because I'm now cutting into my rebuttal time, I did want to talk about how the amended complaint related back, and we have provided 3 different bases for it to do so. The first is MCR 2.118D, and the general law of this state that amended pleadings do relate back to the prior amended pleadings. I'm not going to elaborate given the shortness of time. We also gave the court 2 alternatives. The second alternative is MCR 2.118A4, which provides that, unless otherwise indicated, an amended pleading supersedes the former pleading. And that is exactly what happened here. Our amended verified complaint simply superseded, replaced the prior unverified complaint. And then finally, MCL 600.2301, which we cited in our reply brief, which allows a court at any point in the course of proceedings to allow such amendments as are just and in furtherance of justice. And in Bush v. Shadahang, this court set out the conditions under which that statute can be invoked, and we meet both of those conditions here. So we have 3 bases on which to rule, reverse the Court of Appeals, and indicate that our amended complaint related back. With that, I'll reserve the balance of my time.
Counsel,
Yes,
before
sir.
you do so, MCR 2.118D provides that the relation back doctrine only applies to a claim or a defense. Didn't you indicate a few minutes ago, or did I mishear you, that a FOIA request was not a claim?
Well, first of all, Your Honor, I respectfully disagree with your reading of 2.118D. It says, if I may, an amendment that adds a claim or defense relates back to the date of the original pleading if the claim or defense asserted in the amended pleading arose out of the conduct, transaction, or occurrence set forth in the original pleading. That's not a bar on an amended pleading which does not add defenses or claims. It simply clarifies that when you add defenses or claims, that is allowed if it relates back. It's not a bar on the amendment that my client made here. It's a clarification of particular circumstances that do not apply to my client because we did not add claims or defenses.
Thank you.
Thank you, Your Honor. I reserve the balance of my time.
Thank you.
Good morning, Your Honors, and may it please the Court. Kyla Barranco on behalf of Attorney General Dana Nessel. Seated at counsel table is Deputy Solicitor General Ann Sherman. Your Honors, at issue today is not whether personal email accounts used for official business are subject to the FOIA. They are. Or whether the state has an obligation to be transparent and provide information in response to FOIA requests. It does. Rather, at issue is how and when the state may be sued under the FOIA in the Court of Claims. The answer to this question is relatively straightforward. The legislature, in enacting the FOIA, has waived the state's sovereign immunity from suit and liability, so long as a claimant complies with the conditions set forth in the Court of Claims Act. Here, Progress Michigan failed to do so when it did not sign and verify its original complaint. Thus, any action by the Court of Claims other than dismissal of that original complaint contravened the legislature's mandate on the conditions on the waivers of sovereign immunity. As this court has noted in construing the language of 6431, there is nothing strict, as opposed to being merely reasonable, in concluding that 6 months means 6 months. Files in the office of the clerk means files in the office of the clerk, and in detail means in detail. The same is true of Section 6431's mandates that no claim may be maintained and which claim shall be signed and verified by the claimant. To allow a deficient claim to be maintained through amendment, relation back, tolling, or otherwise would be to rewrite the legislative mandate. For this reason, the Court of Appeals should be affirmed. Now, Your Honors, in regards to the first question raised by this court, which is whether there's a sovereign immunity or governmental immunity defense to the failure to disclose public records pursuant to the Foia, Your Honors, the state does have a limited sovereign immunity defense to the alleged failure to disclose records under the Foia. And that's because in 1939, when the legislature consented to the Court of Claims jurisdiction, it did waive the state sovereign immunity from suit, but it didn't do so unconditionally. It enacted 6431 and a number of other provisions which set forth certain bars you have to get over in order to bring the claim against the state. Now, when the Court of Claims Act was enacted, the Foia didn't exist. And in any event, if the Foia did exist, it wouldn't have been subject to the Court of Claims because at that time, statutory claims weren't subject to the Court of Claims exclusive jurisdiction. But in 1976, the legislature amended the Foia. And at that time, Foia claims, again, were not subject to the Court of Claims, both by the Court of Claims exclusive jurisdiction set forth in 6419 at the time, and also just by the plain language of the Foia, which said they needed to be filed in the circuit courts. So I think at that time, we could not say that we had a sovereign immunity from suit defense to the failure to disclose records. However, in 2013, that changed. In 2013, the Court of Claims Act was amended to add to the Court of Claims exclusive jurisdictions statutory claims and constitutional claims. Importantly, and they added this language, notwithstanding another law that confers jurisdiction of the court to the circuit court. So even if there is another law that says jurisdiction goes to the circuit court, if you fit within these certain parameters, you have to bring the case to the Court of Claims. And if you bring the case to the Court of Claims, you have to file the conditions set forth therein. Notably, in 2014, I think it was actually less than a year after the Court of Claims Act was amended, the Foia was actually amended. And the Foia was
Counsel,
amended.
I have a question, and just help me to understand this. What would the consequence be if the party just refiled?
Your Honor, in this case, the party refiled in the Foia context or just generally?
Right, what would happen? I mean, but so there's no statute of limitations. What I'm trying to grapple with is if this isn't done correctly, can the party just continually refile?
Yes, Your Honor, I think, so take it outside of the Foia context. So say you just have a normal claim before this court that's not a Foia claim, that doesn't have that odd 180-day statute of limitations. If a plaintiff were to file his claim with the Court of Claims on day one and it was unverified or an otherwise defective, I think the correct remedy would be to dismiss without prejudice. And then within the preceding 365 days or 6 months if subsection 3 applies, you could file as many times as you want in order to perfect it. Here what happened is that they couldn't because of the Foia statute of limitations to run. But still, there's not a harsh result there because what Progress Michigan could have done and what any claimant in a Foia claim can do is if the statute of limitations run, they could simply file a new Foia request. And if our response is the same and they're still unhappy with that response, then again, they can go to the Court of Claims and they could file their complaint and get the relief they seek.
Okay, thank you.
Counsel, can I ask your take on the same question I addressed to Mr. Brewer a few minutes ago? What is this court's interest in addressing this case in light of the fact that if Progress Michigan prevails, they get the documents, and if Progress Michigan doesn't prevail, they may well still get the documents?
Your Honors, this case is important because, while this is a Foia case, it is, but at issue right now before this court, and really what's been at issue throughout this entire litigation is not the Foia, but the Court of Claims Act. And so whether the records exist or not, to my knowledge, they absolutely do not exist. It matters what this court says because it doesn't just apply to Foia claims. This court's interpretation of 6431 is going to apply to all claims.
That would include claims where you do have a statute of limitation, as Brother Counsel kind of indicated. Would you basically kind of recognize the fact that Brother Counsel's argument as it pertains to kind of how this would implicate and impact litigation is correct?
Your Honor, when when the state has a sovereign immunity from suit defense, which is comparable to, say, 11th Amendment in federal court, you can always assert that defense at any time. You could assert it in the Court of Claims, you could assert it in the Court of Appeals, you could assert it right here. However, I will say that in those circumstances where the plaintiff has been misled or, fraudulently led into keeping it, the federal courts would apply a doctrine of equitable tolling in those situations. And so I think that's something that this court could apply if they wanted, but that would be equitable, and there would need to be a reason for that equitable nature. And the federal courts have made that very limited. They've made it in the sense that you've essentially been misled. And for that reason, you should have this tolling application apply.
But I guess, I'm sorry.
Oh, no, I was just going to follow. So is that, the Attorney General's position is extending Scarcella to this context is appropriate if we also add on an equitable tolling doctrine? So we have the, you just want us to add some more stuff?
No, Your Honor.
Even though there are statutes that,
That's just to address Justice Bernstein's position that, you have this action where someone's been led on for, say, 2 years. I'm saying that
Mr. Brewer raised a good question. What happens when, if Scarcella is extended to other contexts, why wouldn't every defense attorney just litigate until the statute passes and then file a motion saying, oops, it was a nullity, you're out of luck?
Your Honor, I think it's important to recognize that while Scarcella is a useful analogy, Scarcella doesn't apply to this case. It doesn't, and Scarcella will apply to the majority of cases. However, the reason...
So it doesn't apply to this case, so do you agree with Mr. Brewer that we should reverse the Court of Appeals on that?
Your Honor, I think that in regards to the med-mal arena, I suppose I wish I could offer some wonderful advice why you should overturn it. I think that in this context, though, it does not apply at all. And I think that's important to recognize because in Scarcella, you're dealing with an affidavit of merit that's attached to your complaint. Here, you're dealing with a condition on the waiver of sovereign immunity from suit. So if you look at Section 5856, which says that the statute of limitations or repose are told at the time the complaint is filed if a copy of the summons and complaint are served on the defendant, which happened here.
Yeah.
If you go to B, it says at the time jurisdiction over the defendant is otherwise acquired. And that presupposes that under A, you have acquired jurisdiction. And in the majority of cases, almost all cases, that is going to happen by doing A. But it doesn't happen in the context when you're dealing with a condition on the waiver of sovereign immunity from suit. Because a condition on the waiver of sovereign immunity from suit means that the legislature has said, you may sue the state, but you may only do so if you do this and that. And if you don't do that, the state has not consented to be sued in a court's jurisdiction. So unless you comply with those conditions, jurisdiction hasn't otherwise been obtained over the defendant. And that's why Scarcella, I think, is
So you want us to affirm the Court of Appeals, but for different reasons?
Well, Your Honor, I think-
You agree with Mr. Brewer that Scarcella should not have been extended here, it sounds like.
I don't
Just want to understand the position of the Attorney
Correct. I
General.
don't think Scarcella should be extended here. I think they used it as an analogy and they didn't necessarily say, because of Scarcella, this is why this applied. I think what the Court of Appeals did was say, here's another area where this is similar. And in order to kind of make it a helpful analogy, I don't think that they necessarily relied on Scarcella.
So I understand your position here. There's sovereign immunity. Sovereign immunity is waived by statute. The statute requires the complaint to be verified. If you don't comply with what the statute requires, there is no waiver. Therefore, the government still has sovereign immunity. Because the verified complaint, what was required by the statute, was not done within the time frame, then there is no bar to immunity, that there's no lawsuit that can be filed. Scarcella never comes into play.
Correct.
Now, this was a settlement where it would have gone forward with stipulation from both parties that we vacate the Court of Appeals opinion. I can understand the appellant coming in and telling me what's wrong with the Court of Appeals opinion, but you stand here now defending the Court of Appeals opinion. Why did you want that opinion vacated?
Your Honor, it's the department's position that, to be quite honest, the Court of Appeals opinion, we deal with these issues all the time. The Court of Claims Act, maybe not in the Foia context, but the Court of Claims Act is constantly at issue with the state. We are constantly in the Court of Claims on it. So this issue is bound to come up before this court again with the number of cases we have involving 6431. So to us, Progress Michigan, while we think it stands for a good proposition, we're not losing that much by it being vacated, because I think that we could come up with this argument again. And I think the Court of Claims, in a lot of senses, has applied Progress Michigan's line of reasoning.
So you have no issue with the Court of Appeals reasoning, even though they went to Scarcella and you say it's not applicable?
Correct.
You're just willing to give up this published opinion because it'll come back again and you get the case to go away?
That was the reasoning in the motion to vacate, yes, Your Honor.
Didn't this court raise a Scarcella-like argument in Fairley? Have you made that argument?
Your Honor, they did in Fairley. I think Fairley is distinguishable from this case, and I think you have to go down a different path, because in Fairley, they were outside of the one-year period. So no matter what they could do, they just couldn't bring the claim against the state. But though and saying that, I think that they did, in a sense, raise the Scarcella argument
I'll quote
there.
from it specifically. We also reject Plaintiff Stone's notice for the similar reason that it was not clear from the face of the document that it was verified, quote, before an officer authorized to administer, quotes, oaths, unquote. We are unpersuaded that the belated affidavit of plaintiff's counsel asserting his due role as attorney and notary public can cure this deficiency. Plaintiff Stone's notice was either unverified but timely or untimely but verified, and in either circumstance, it fails to meet the conditions precedent to maintaining a suit against the Michigan State Police. Isn't that a close analogy to what Scarcella was articulating in a different context?
It is close, but I think that there's a crucial distinction. In Fairley, and also in McCahan, what happened was not that the plaintiffs filed a complaint. They filed notices within that one-year period. So because they didn't file a complaint within that one-year period, the tolling wouldn't come into effect. And in any event, I don't think tolling should even come into effect when we're talking again about sovereign immunity from suit, because it would assume that the court has jurisdiction over that claim.
Can I ask you too, do you agree with everything that Mr. Brewer said concerning the propriety of suing the Attorney General as opposed to the state of Michigan, as opposed to the Bill Schuette in his public capacity? Can you just clarify for me what you understand to be appropriate in these kinds of FOIA lawsuits?
Sure, Your Honor, and I think the answer to this question is you just have to look at the FOIA. And under the FOIA, you're authorized to sue a public body. And a public body is defined in a number of ways. It could be the head of a department, it could be the department itself, it could be an agency, it could be a commission. So here, what Progress Michigan has done is that they have sued a public body. There's no individual official capacity here. You've sued a public body. You've sued the department, really, because what's at issue is not Bill Schuette's personal records. They're the records of the public body at issue. So that whole distinction, I don't think, really comes into play.
But the act defines a public body to mean, among other things, a state officer, employee. I mean, it gets to individuals, doesn't it?
Correct. I just don't think that the whole official capacity, individual capacity really serves.
No, but is there a distinction between the state and a state department and a state officer, like the Court of Appeals said after, in its later decided opinion in Pike, or is there not?
Your Honor, in Pike, I think the Court of Appeals erred, because I don't think that 6431 gives that reading, and I think there's several reasons why. And the first is that this court has applied 6431 to agencies, to departments. For example, in McCahan, it was against a university. In Fairley, it was against the Department of Corrections and the Department of State Police. Recently, in Bowserman, this court applied it to the Uninsurance Employment Agency. Additionally, I also think it's very important to note that under the Court of Claims Act, it's not the state that pays this money. It's going to be the department commission identified in that notice. So it's not coming out of the state's pocket. And really, what is the state's pocket? It's also important for the FOIA, too, because here, even though Bill Schuette is the head of the public body, or was the head of the public body, the FOIA provides that if the head of the public body at issue...
I guess I would say, under the FOIA Act, Bill Schuette was the public body. 'Cause
He
it
was
says
the public
body means any of the following, a state officer.
Correct. He was the public body at issue in this case. However, under the FOIA, if a state officer is the head of a public body, he does not get damages assessed against him. It's the next higher public body, meaning the Department of Attorney General, that would do so. So I think Pike is incorrectly decided. If it applies, then I would have to concede that he sued an officer and not the state.
Counsel, can I ask a
So wait,
question?
I
Oh, I'm
just
sorry.
want to, before, I apologize, but before, I want to explore the extent to which you believe that. So you believe any lawsuit against anybody who works for the state of Michigan in this context should be considered a lawsuit against the state? So even if it's just an employee, like that would be considered a lawsuit against the state?
Correct, Your Honor.
Okay. I'm sorry, Justice Burns.
No. I just like to try to keep it simple sometimes. And I guess what I'm just having a hard time, and I want you to help me with this, I'm just trying to understand, I'm trying to grasp your argument, and I'm just going to kind of ask this question, even though it's very simplistic. Can you outline for me exactly, specifically, what the harm is in turning over these documents? I'm trying to understand if you could just give me like a succinct understanding. I get that it's very complicated, but basically give me a nutshell as to exactly what the state's concern, what the department's concern is in releasing these documents.
Well, Your Honor, to my knowledge, these documents don't exist, except for the one that we identified in the final determination to Progress Michigan. And while Progress Michigan identified some documents that it believed the department had, I would note that whether it got those documents in a previous FOIA request, there are various retention schedules that apply to documents. And one that comes to mind is the one for transitory records. And if something is a transitory record, which, to be quite honest, encompasses quite a bit of records, it can be deleted upon creation. So most emails I send throughout the day can be deleted upon creation. Additionally, the email that Mr. Brewer attached to his reply brief to Matthew Snyder wasn't actually sent to Matthew Snyder if you look at the email. It was sent to Matthew with 1T Scheider. So that's no evidence that that document was actually received by the state. But going back to the heart of your question, even if the documents did exist, the harm comes back to sovereign immunity from suit. To say that the legislature has said you can sue the state, but you may only do so on these conditions. And if you don't comply with those conditions, you have gone around and rewritten essentially the legislature's waiver on the condition of sovereign immunity. And so that's the harm here.
So that comes into play here where we have a short statute of limitation, and that's what's barring the suit. How would this rule, if we were to adopt it, apply to other cases outside of FOIA? And is there any obligation on the part of the defendant to respond in an answer to the complaint to say, hey, you failed to verify? Here, the 6-month period ran, and now it's barred, but in other cases, what is the implication of us taking that ruling as it relates to other cases? And isn't there an obligation on the defendant to raise this point responsibly to the pleading so that at least the other parties on notice and have an opportunity to amend if there's time?
I do think that the FOIA is an interesting beast, as you will. Probably the FOIA and the OMA are the only two statutes of limitations that I know of, at least, that have this 180 days. So I really think that's only going to come into play here. With other statutes, I don't think it will be affected for the reason I said earlier. For the reason that if someone were to file a defective claim or notice, they still have that year to go ahead and refile as many times as they like. It should be without prejudice within that 1 year, 6 months. Now, in regards to whether the state has an obligation to raise it, sovereign immunity is an affirmative defense, so it should be raised. And like in this case, we didn't file an answer right away. We filed a motion to dismiss based on sovereign immunity and highlighted to the other side exactly why we thought their pleading was defective. And in my experience—
Within that 180-day period?
No, Your Honor, but I don't think you could fault the department for that, because Progress Michigan filed on day 176 of 180 of the statute of limitations. And so while the department did receive it on day 176, I think due to all of the red tape and going around, we wouldn't be able to respond to that within that 4-day period. However, I think in normal FOIA cases, we do file motions for summary disposition right at the get-go if we feel we can, or otherwise we'd be required to file an answer. So had it been filed at the beginning of the statute of limitations period, I don't think we would have this problem. Your Honor, I think I've touched on the first two issues, but in regards to the third, which is whether the notice and verification requirements are applicable to a FOIA appeal, I would note that first, we're not dealing with a FOIA appeal here, we're dealing with a FOIA claim. And that's evident by MCL 15.240 sub 1 A through B, which provides that if a public body makes a final determination to deny all or a portion of the request, the requesting person may do one of two things, essentially, or both. Submit to the head of a public body a written appeal, or commence a civil action in the Court of Claims. So what Progress Michigan did here was they commenced a civil action in the Court of Claims. In any event, the plain language of the Court of Claims Act demonstrates that the legislature intended for MCL 600.6431 to apply regardless of the claim being brought. And I think you just really have to go back and look at the 6431 language to see that. 6431 makes no distinction among the types of claims subject to its requirement. And had the legislature wanted to do so, it could have. And I think there's two examples of that. First, if you look at sub 3, it delineates certain types of claims that are subject to a shorter statute of limitations period, those for personal injuries or property damage. And additionally, this hasn't been in the briefs, and it hasn't been passed by the legislature, but this just passed the legislature, I believe, or the House unanimously, that they're amending 6431 to exclude at least one type of claim, and that would be claims under WICA. So had the legislature wanted to exclude FOIA from there, it certainly could have. In regards to the fourth issue, and that's whether the Court of Appeals erred when it held that plaintiff's failure to follow the verification requirement in its original complaint rendered the complaint invalid from its exception. Again, Your Honors, I think the important point here is that when the government waives its immunity from suit, it may do so on its own terms. So if you don't meet its terms, then the state has not subjected to the court's jurisdiction. And any relinquishment of that sovereign immunity must be strictly interpreted. And this court and the Court of Appeals and the Court of Claims uses that language strictly interpreted quite often. But I don't know if it's ever actually been delineated on what that means. But if you trace it back, all of the Michigan Supreme Court cases essentially go back to federal law on the subject, and the federal law on the subject is in regards to 11th Amendment immunity. And strictly interpreted would mean when confronted with a purported waiver of the federal government, or here the state government's sovereign immunity, the court will construe ambiguities in favor of immunity. So in essence, you give deference to the government if there's an ambiguity. Now here it says, no claim may be maintained against the state, which claim or notice shall be signed and verified by the claimant. Again, here, Progress Michigan failed to do so, so its claim should have been dismissed at its get-go.
Can I also explore the extent of your jurisdictional argument?
Absolutely, Your Honor.
As I understand it, your position is if there's any deficiency, procedural deficiency, related to a requirement under the Court of Claims Act, then the Court of Claims, in the party's pleading, then the Court of Claims doesn't acquire jurisdiction, and therefore the statute of limitation is not told. Is that correct?
Correct, Your Honor.
The Court of Claims Act in Section 6422 also says practice and procedure in the Court of Claims shall be in accordance with the statutes and court rules prescribing the practice in the circuit courts of the state, except as otherwise provided. So does that also mean that any procedural deficiency or failure to strictly comply with any court rule then renders the Court of Claims jurisdiction void?
No, Your Honor, it does not. And
How
I
do you
think
make the distinction?
because court rules don't implicate the state's sovereign immunity from suit. The legislature, when it enacted 6431, it was welcome to incorporate all of the requirements under the court rules, expressly so to say, you must also do
Well,
all of
did
these
it do
things.
that in 6422?
I think 6422 just means the practice and procedure. It doesn't have to go to the state's conditions on the waiver of sovereign
Well,
immunity.
doesn't
from suit.
verification of a complaint, isn't that a procedural requirement?
It is a procedural requirement, but it is required under the Court of Claims Act. And going back to your question here, it's required in 6434. The complaint shall be verified. So under
I mean, I get that, although I do think it's interesting the case has traveled this far, and we have not been alerted to 6434, as far as I can tell from the pleadings of any party, number one. And number two, I'm still scratching my head at why the Attorney General's Office of the State of Michigan can't figure out if this complaint is properly verified or not. Do you think the complaint is, the amended complaint is properly verified?
Your Honor, I think the complaint, we have never raised that it has not been properly verified.
Well, you did as it relates to the original complaint, but then you stopped paying attention to the amended complaint? You just said, if you filed anything, you'd say it's verified?
Your Honor,
Because it has a notary signature on it?
it does have a notary signature on it, the amended complaint.
Yeah, what does that mean? That means that the notary
it's sworn.
says the person who signed the complaint is the person that they said they were. That's all that means, I think.
Your Honor, I think it means that they've sworn to the truth of the matter
Well,
asserted
how would you
therein.
know that? Because it doesn't say that. You just think that maybe the notary asked the person, even though it's none of her, or his business, they might have said, are you sure this is all right? And they said, yeah, I think so. So then we just assume that happened?
I think that's the purpose of a notary, is to swear that everything that
The
you're.
notary just as far as I know, verifies that the person signing the document is actually that person. Isn't that their job? They don't.
That's
they
not
don't.
my understanding of the
So they're like a
notaries.
private investigator. They investigate the facts and then they say, well, so if I'm going to notarize this, then I'm also going to verify that it's all true when I write my name on here?
I don't think the notary is swearing that it's all
Put
true.
my
I think
jurad
that the
or
notary.
whatever they call it?
The notary is swearing that the person who is signing the complaint is swearing that it's all true.
But only if the person, they notarize it under a little statement that says it's all true to my knowledge, information, or belief, or even stronger, to my knowledge, it's true. Then they sign it, and the notary notarizes their signature.
Your Honor,
There's an important step that's missing here that makes my head explode as a former trial judge
I
and
was about
trial
to say,
lawyer.
as a former trial judge.
So, yeah, anyways, go ahead.
Well, I would say if that statement is required, I declare under penalty of perjury X, Y, and Z.
That's
as-
one way under the court rule.
Correct, or any of the other ways, and that the amended complaint was deficient, then it would not be under 6434, a verified complaint. It wouldn't matter in this case. Because at the end of the day, that would assume that that amended complaint, there's something even to amend, something to relate back to,
Well,
something
now
to be
you're
told.
sounding a lot like you're on the Scarcella train, which I sort of disagree with Justice Markman. I think that leads us to all sorts of chaos, and depending on how we rule on this case, could be inviting that chaos in pretty much every area of the law. But you just said a few minutes ago you weren't on the Scarcella train.
No, you're right. Well, I think Scarcella, again, is analogous to this case, but it's a different arena. I think that sovereign immunity from suit
But if
is
this
its own.
case, does this case exist or does it not exist? Is it, I think the amicus called it a spectral case. Is it an illusion, a mirage, or is it a lawsuit?
Your Honor, I would argue that because the claimant didn't comply with the conditions set forth
So the
in
case never
6431, they
existed.
don't have jurisdiction.
Why
on the
did you,
case.
let me ask you this, why did you respond to it? Why didn't you throw it in the wastebasket?
Well, Your Honor, I think that goes back to the question posed earlier by Justice Bernstein. I think the state is under an obligation to assert its defenses, and
Well, that's not what Scarcella says, and that's not the logical implication of Scarcella, or even how this court has interpreted Scarcella in other contexts, like it did in Auslander, where it said, since the no complaint has been filed, there's even no obligation to assert an affirmative defense. I mean, the whole thing leads to anarchy, which this court pointed out, as counsel suggested in Safian, where, and I think I tried to point out in some statements, that thank God no party actually believes we meant what we said in those cases, and people do file their answers to the complaint and their motions for summary disposition, and at least give the court the courtesy of ruling on their legal defenses.
well, Your Honor, my only response to that is I think the state likes to avoid default. And even if the entry of default.
But you're
wouldn't be
wasting my
entered.
tax dollars if Scarcella is actually the law, because there's no case to respond to.
You're correct, Your Honor. There is no case to respond to, and I think that is a logical reading.
Are you backing off your position now that sovereign immunity existed and the waiver to sovereign immunity came by way of statute? The statute defined what had to be done when they didn't comply with what was stated in the statute? You do not waive sovereign immunity.
Correct, Your Honor.
No need to look at Scarcella.
Yes, absolutely. I think that's it. The legislature has waived its sovereign immunity from suit, but only if you comply with the conditions set forth in
And that has
6431.
nothing to do with Scarcella.
Correct. Scarcella relates to the tolling of a statute of limitations, which outside of a case under the Foia, which has such a short statute, wouldn't come into play here because we're not talking about a statute of limitation. We're talking about a condition on the waiver to suit. And for that reason, I would ask this court to affirm the Court of Appeals. Thank you.
Thank you, counsel.
Thank you, Your Honors. Just a couple of brief comments. Justice Viviano, this is a real case. It's a real case under 600.1901 and .5856, because a real case is commenced simply by filing a complaint. That's the statute that Scarcella and the Court of Appeals here ignored, and it applies to all litigation without exception. There's no exception in the Court of Claims Act that says, oh, guess what? .1901 doesn't apply.
I would think of these manila case folders that they handed me when I was a trial judge, and I would read these cases and think, it sure looks like a case. It has a folder. There's documents in there. We've given it a case number. It has a case name. We keep having to talk about the case in court. It seems very strange to say that that's not actually a case.
I agree, Your Honor. And 600.5856 makes this a real case as well, because that applies by direction of the legislature, which also enacted the Court of Claims Act, to all cases that are commenced that toll the statute of limitations. That is a blanket statute. Opposing counsel claims 6431 is clear. I agree. It requires damages in order to apply. But if 6431 is clear, so are 1901 and 5856, and they clearly apply here. This whole notion that somehow the court can deal with the chaos that Scarcella would engender if expanded by equitable tolling, that's just an invitation to further litigation, further fighting, all to deal with something that can be simply dealt with by rejecting this whole notion that somehow you have, as Amicus said, spectral lawsuits that parties may or may not have to answer. And some smart defense lawyers are going to start to figure out we don't have to answer, and away we go.
Mr. Brewer, what do you make of, it sounds to me like the Attorney General's position is not really that it's a spectral case. I know there was a little back and forth on that, but that it's, that sovereign immunity is somehow not waived when a procedural requirement is not. Sovereign immunity is not waived because of the procedural requirement.
Well, this court has said in the Mick case, a very blanket statement, I quoted in my brief, that common law sovereign immunity no longer exists in this state. That's all I can do is cite this court's own decision in Mick versus Kent County.
I think counsel would say that the legislature brought it back in the Court of Claims Act.
Well, they may have attempted to bring it back through statutory means, but the whole concept, the common law concept of sovereign immunity, let's set that aside, doesn't exist anymore by this court's own decisions. But again, you have to look at the text of 6431. The subsection 1 requires parties to list items of damages claimed to have been sustained. That doesn't apply here. My client seeks no damages. My client seeks public records. So by its own terms, 6431 does not apply. The other statutes that have been cited give jurisdiction to the Court of Claims, but they don't condition that jurisdiction on compliance with the verification and notice requirement. The legislature could have done that. When it amended the Foia, all it said was file in the Court of Claims. It didn't say file and follow the notice and verification requirements, file and follow all the Court of Claims requirements. It simply moved the jurisdiction for Foia cases from the circuit court to the Court of Claims. That's all it did. And those are the express words of the statute.
Mr. Brewer,
That's what the text says.
does either 6431 or 6434 either directly or implicitly reference waiver of immunity?
No, I mean, that is again the argument that has been made here that somehow if you don't comply,
With a
immunity has not been
procedural
waived.
requirement that somehow waives immunity?
No, it makes no reference to immunity at all whatsoever. And again, we have to go back to the other statutes that talk about a case is commenced under the generally applicable statute, and the statute of limitations is told. This whole idea that somehow sovereign immunity pops up like a specter and means that there's no lawsuit that's been filed between you and front, that ignores the other two statutes. And that's the error that Scarcella committed, and it's the error that the Court of Appeals committed.
Counsel, can you help me to understand, because I always think this is important, help me to understand what would the implications be if the state were to prevail? What would the effect be on people?
Well, I think the effect would be on people, as we have been talking about here this morning, that thousands of defense lawyers in this state would now start to search for every conceivable defect under statute or court rule when a complaint is filed and say, this complaint is a nullity. I have no obligation to answer. I can sandbag the plaintiff, stretch out the litigation until the statute expires, then say, oh, nullity, file a motion. None of this applies to me. I think it's chaos. And that will affect the clients of those people as well. They'll lose rights to file all kinds of lawsuits, Your Honor, in this state if, in fact, creative defense lawyers, and there are many of them, can say this lawsuit's a nullity, no matter what area of the law it's in. I think Justice Viviano correctly pointed out, I'm worried about the damage in the Foia area and the Court of Claims Act, as Justice Viviano pointed out, that if the Court of Appeals is affirmed here, that damage is not limited to those two areas of the law. It could extend throughout the entire body of law in this state.
Thank you.
Thank you, Your Honors.
Part of your argument, and what I hear you summing up, is that that FOIA claims have to be filed in the Court of Claims,
Yes,
but
Your Honor.
that nothing else in the Court of Claims Act applies. Can
Not
you
a-
give us any other similar circumstance where you see that?
Not off the top of my head, Your Honor, I can't. I think what has happened here is the legislature had the opportunity when it amended the Freedom of Information Act and the Court of Claims Act back in 2014 to add other conditions. It could have resurrected sovereign immunity at that time and said, you have to comply with these other conditions when you file that lawsuit. All it did was move the jurisdiction from the circuit court to the Court of Claims. That's all it did.
There had to have been a reason for that. I mean, it's odd to say, okay, well, it's in circuit court, now it's in the Court of Claims, but none of the requirements that exist in the Court of Claims apply to FOIA cases.
Your Honor, all I can do is read the words of the statute. And the legislature knows how to add notice requirements when it chooses to. Our statutes are replete with notice requirements. Notice of road defects, notice of claims of damages, 6431. But when the legislature amended the FOIA, it didn't add that language. It simply said file in this court.
And I can understand your argument there when it comes to 6431, but and I understand it hasn't been argued, but when it comes to 6434 too, it is in there. So why wouldn't that section apply?
Well, again, none of this was incorporated by reference when the legislature amended the FOIA or even amended the Court of Claims Act. If you look at the section 6419, it's entitled Court of Claims Jurisdiction. It's a jurisdictional statute that simply says jurisdiction over these cases lays in this court now. That's all it does. It does nothing substantive. It simply shifted jurisdiction from the circuit court to the Court of Claims. If there's nothing else, thank you all very much.
Thank you very much. The case will be submitted.